Today on The Right Slant, we're breaking down exactly how firearm confiscation works in the state of South Carolina and what you must do to legally get your gun back. We'll look at the most common reasons firearms get seized, the legal requirements for return, the steps you have to follow, and 2 real South Carolina cases that show how the courts actually apply these rules. By the end of this video, you'll know precisely where you stand and what actions you need to take. In South Carolina, firearms can be confiscated under several circumstances. Here are the most common. Arrest involving a firearm, the gun is seized as evidence under SC Code Section 23-31-215 subsection K. Domestic violence incidents. Officers may seize weapons present when probable cause exists for domestic violence. Violation of protective orders. A firearm possessed while under a valid restraining order can be confiscated. Unlawful carry or concealed weapon violations. If you're arrested for unlawful carry, your firearm is typically held as evidence. Use of a firearm in a criminal act, even misdemeanors involving threats or brandishing, can result in temporary seizure. These situations do not mean permanent loss, but the return process is tightly regulated. In South Carolina, firearm return is dictated primarily by SC Code Section 16-23-490, Section 23-31-215, and local law enforcement evidence procedures. The key points are: a firearm cannot be returned while criminal charges are pending. Once charges are dropped, dismissed, or you're found not guilty, you can petition for return. You must not be prohibited under federal or state law, for example, due to felony conviction, domestic violence conviction, or active restraining order. Law enforcement must verify you are legally allowed to possess firearms before release. Agencies often require a court order, especially if the gun was seized during a domestic violence call. The return is never automatic. You must request it. Here's the step-by-step process that applies in most South Carolina jurisdictions. Step 1. Resolve all charges. Your case must be closed with a dismissal, non-prosecution, or acquittal. If you pled guilty, the weapon may be forfeited depending on the offense. Step 2. Request a property release. Contact the law enforcement agency that seized the firearm. This is typically the sheriff's office or the local police department. Ask for a property release form or instructions for filing a return request. Step 3. Provide documentation. You may need case disposition, government ID, proof of ownership. Step 4. Background verification. Agencies run a state and federal check to ensure you are not prohibited. This is required under both South Carolina law and Federal 18 U.S.C. Section 922. Step 5. Court order if required. Domestic violence or protective order. Related seizures often require a judge's written order before the firearm can be released. Step 6. Make an appointment for pickup. Firearms are never released on demand. They are scheduled by the evidence custodian. And right here in the middle of the video, don't forget to like, subscribe, and hit that notification bell to support The Right Slant and help more people understand their rights. In State v. Blanding, officers seized a handgun during a domestic violence investigation. The defendant was later acquitted, but the sheriff's department refused to return his firearm without a court order. The Court of Appeals ruled the agency acted appropriately because domestic violence seizures require judicial oversight before release. This case reinforces that even after acquittal, the return process is not automatic. You may need to petition the court. In State v. Brown, the defendant's firearm was seized after an arrest for unlawful carry. The charges were dismissed, and Brown asked for the gun back. The court ruled that because the firearm was not contraband and Brown was not a prohibited possessor, the gun had to be returned. This case is important because it confirms that when charges are dismissed and no legal prohibition exists, South Carolina law requires the firearm's release. To wrap up, if you're legally allowed to own firearms and your charges were dismissed or resolved in your favor, South Carolina law supports your right to reclaim your firearm. But the process requires action. You must make the request, provide documentation, and sometimes obtain a court order. Agencies cannot permanently keep your firearm unless it is contraband, you are legally prohibited, or a judge orders forfeiture. Understanding these steps protects your rights and ensures you don't lose property simply because it entered the evidence system. Thanks for watching The Right Slant. If this helped you understand South Carolina's firearm return process, make sure you like, subscribe, and hit that notification bell so we can keep bringing you accurate, fact-based breakdowns of your rights in every state. I'll see you in the next video.